Karen, that'd be perfect. All right. Good afternoon. This is Delegate Charlotte Crutchfield, and you are here for the March 4th meeting of the Family and Juvenile Law Subcommittee of the Judiciary Committee. And we have several bills that we will be working on this afternoon. We're going to start off with HB 406, which is sponsored by Delegate Simpson. And that's the Marriage Confidential Communication Criminal Charge. And Delegate Simpson, can you give us like a 10-second summary?
Yes, everybody should have the amendment that we talked about the last time, so it should be good to go and everybody should be excited about it.
Are there any questions about this bill? And this is just the amendment, I think, clarifies a little bit more and specifically talks about a spouse and I think it's former spouse, right?
So the idea was divorces are happening so quickly, it's possible that they could be a former, and therefore wanted to make sure it clarified, still during marriage, still clarifies that. It just means it could be a spouse or former spouse.
Right. That can communicate on certain limited issues.
Right. The communication had to occur during the marriage, but it is possible that the person is now a former spouse and not a current spouse.
Okay. Are there any questions for the committee to Delegate Simpson about the bill or the amendment? So we're going to go with the amendment first. Are there any questions regarding the amendment and what it does? Okay, I don't see any questions about that.
Move favorable, Madam Chair.
Do I have a second?
Second.
Okay, great. And so all in favor of the amendment, please raise your hands. All right. And that looks like that's unanimous. All right, we're going to move to the bill itself with the amendment. And what we will need to probably do is, just to be on the safe side, we'll do a voice count on that. But do I have a motion on the bill?
So move.
And do I have a second?
Second.
Okay, great. All right, so we're going to do, again, a voice vote on that. So I'm going to start off with Delegate Bartlett. I don't think she's here. Delegate Boucher.
Yes.
Okay. Delegate Kaufman.
Yes.
Okay. Delegate Pastor.
Yes.
Delegate Sample Hughes, I'm sorry. Delegate Simmons. Delegate Simpson.
Yes.
Delegate Taylor.
Yes.
Delegate Tomlinson. Delegate Valentine.
Yes.
And Delegate Crutchfield, yes. So I believe that's unanimous. All right. First bill out for today. Let's move on to 648, and let's let in Michelle Smith, who is from the Maryland State Bar Association. Okay, great. Hello, Ms. Smith. How are you doing? All right. I'm gonna, because this is a bill I sponsored, and I'm gonna just briefly go over it really quickly. Again, this is to really equalize how income regarding child support is calculated, because right now, those people that do not have taxable income, their income is not allowed to be, there's not discretion with the courts to actually gross up their income. So it's reflective of what truly income should be when you're dealing in child support issues. And so there's an amendment, and the amendment is to clarify that, and just simply states again that for a parent with a non-taxable earned income from an employer, the amount of federal, state, and local taxes, including Medicare taxes and any amount required to be withheld under federal insurance contributions, would have been withheld if the earned income were taxable. So that's what it does. It puts it back into the state where there is some equity with that. Does anyone from the committee have a question regarding the amendment? All right, Delegate Boucher, go ahead.
Thank you, Madam Chair. I'm still trying to get my head around this non-taxable income. Can you once again give us a scenario where this is applicable and how we would what is the problem we're trying to address and how is it applicable? Thank you.
Sure thing. And you know what? I'm going to let Ms. Smith, would you be willing to do that for us? Okay.
Absolutely. Thank you, Madam Chair, and hello, delegates. Yes, this is a little bit confusing if you're not familiar with people who work for, by example, the World Bank. And the delegates from Montgomery County and Prince George's County may be more familiar with this because they bordered the Washington, D.C. area. And I think this is primarily in our state where parents may be receiving income that is not taxable. So parents that work for the World Bank, they receive gross income that is not taxable. So they may never file a tax return and they do not have the standard type of gross income that is then reduced by their tax filings or their tax deductions on their pay stubs. So the World Bank gives them the gross income that is not subject to tax, and that is compared to potentially the other parent who is making standard W-2 earned income like we all think about, where you see the gross income and then you see it being reduced by the taxes that are deducted on their pay stub. So we're not in that circumstance. We're not comparing apples to apples. The parent who works for the World Bank is having income that is not the same as the other parent. So in order to make them on even footing for comparison purposes for the child support guidelines, the other parent wants to gross up the income of the World Bank parent so that they're compared the same. And by grossing up, they would add back into that parent's income the amount that would have been deducted for federal, state, and local taxes and FICA, which is Social Security, if the parent had those things deducted from their pay, so that each parent is being compared on the same level playing field for the guidelines, because the algorithm assumes that you're making W-2 income, earned income, that is reduced by taxes. So in order for the algorithm on our fabulous child support guidelines to work properly, we would have to gross up World Bank parents' income. Now, the court, many cases have come before the court, and some of the cases in which this has happened, the parties even stipulated as to what the gross up amount would be, because everybody agreed that would be the fair thing to do to get the right amount of child support to be paid by the obligating parent. The court said, no, can't do it, even if the parties agree, because it's up to the legislature to tell us to do that, to allow us to do it. And that's why we made this fix, because cases that don't get litigated, the parties settle and they agree to this and everybody's fine. But the cases that go to trial, the courts have actually issued opinions in two different cases, Lemley and Ruiz, that say we're not allowed to gross it up.
Thank you, Ms. Smith, for the clarification.
You're welcome. Clear as mud, I'm quite sure.
Are there any other questions by the committee? Okay, seeing none. Is there a motion?
It
Madam
looks like
Chair?
Delegate
Yes.
Valentine and Delegate Taylor had questions.
Oh, great. Okay, thank you. Did not see their hands. Go ahead, Delegate Taylor.
Thank you. And maybe we have the same. I'm still a little confused about how this works. If first of all, I guess to level set, is your child support payment based upon your gross or your net income?
It's supposed to be your gross income.
It's supposed to be your gross. Okay, so if I work for the World Bank,
Mhm.
my gross is what I make, right? Because if I was subject to taxes, those things, those expenses would have been taken out.
No. So the World Bank employees, as well as IMF, and I think there's a couple of other entities like that, they only pay you a net amount. And the expectation is that you are supposed to, for example, if you live in the state of Maryland, you would be expected to figure out what your tax would be based on your net income.
So
Okay.
they don't call it a gross?
No, they do not call it a gross. It is a net amount that you are receiving.
Wow.
I don't know if there's another way to put it. Let me think. Lauren, are you familiar at all a little bit with it? Is there another way to put it? Because I think that's it, unless Ms. Smith, unless you have something else to add.
I think another way to say it that's helpful to me is
Mhm.
that World Bank parent actually has more income from which he or she could pay child support than standard W-2 parent.
Right.
So in other
And
words,
that is because the guidelines assume that you're paying taxes, that each parent is paying taxes, but World Bank parent is not.
okay. So if I'm a W-2 employee making $32,000 a year, but that's my gross. But it's all subject to taxes. If I'm a IMF employee making $32,000 a year, they consider that a net, which is not subject to taxes.
That is correct. You will get more. I mean, when you look at the basis for the income, in the state of Maryland, you're required to, at least the family law requirements for income computation is based on that gross amount. It's not based on net. So that's part of it. And again, receiving a net pay will come out more than, which means you're actually subject to more, without it being grossed up.
Yeah, but what about my ability to pay? It's still the same though, right?
So
So
remember one thing, Delegate Taylor, is that most of the World Bank and IMF employees are high earning
I
employees.
understand. I know a few.
Okay. So
Yeah.
it's a little different because also in the military, this sort of happens as well. Okay. Depending, if you receive VA funds, sometimes that's not actually taxed, but it's different. Okay. Because there is something coming out. There's usually FICA. There's something coming out though. Okay. Whereas with these folks, there's really not anything coming out.
I could offer one more bit of helpful information, and that is in these cases, for example, with the World Bank, the parent who works for the World Bank is able to ask for the gross up figure, and the World Bank will provide it, but then it can't be submitted into court because the court's not able to include that as actual income per our statute. So everybody agrees that it should be done. And there's even a document that would say what the actual income is, but the court's not able to receive it according to our case law.
Are you sort of getting there, Delegate Taylor?
I get it. I get it. It's just I was wondering if we were creating a new category of sort of income called gross up income for just these employees of World Bank and others. But yeah, I mean, I guess if what you're saying is pretty much somebody W-2 making $100,000 a year might be equivalent to somebody making $150,000 a year at the World Bank potentially. Or maybe that's the other way around. Maybe it's a 201. I don't know, but
Right. But yeah, we're not
I will
creating.
trust the judgment of those that know more than me. Thank you.
Yeah, so we are not creating a new category. We're actually trying to execute what is already in place, except that the courts just don't have discretion to make sure all parents are evenly, how do I want to say, yoked with calculations on child support. So, okay, Delegate Valentine, did I see you as well?
Yes, thank you, Madam Chair. And I
Sure.
believe Delegate Taylor and Delegate Boucher's questions pretty much answered mine. I just wanted to confirm with Ms. Smith, this really does impact just a very few small select group of individuals. Is that correct?
Yes, delegate.
Thank you. That's all I had. Thank you.
Okay, do I see any other questions? Okay, I think we've answered all the questions. And can I get a motion on the amendment?
Move the amendment.
Thank you. And a second?
Second.
Thank you. And so let's take a hand count on the amendment, please. So everybody moving on this motion, please raise your hands. Thank you. Thank you. Thank you. Okay. All right. I think that's unanimous. All right. So is there a motion on the bill itself?
I move favorable, Madam Chair.
Okay. And do we have a second on that? All right. And let's go ahead and do a roll count on that motion as well. Delegate Bartlett,
I think Delegate Valentine was just
Oh.
about to say something.
were you?
Madam Chair, what bill number is this?
This is 648, HB 648.
Thank you.
Sure. Any other discussion or questions? Thank you for pointing that out to me. Any other questions? Discussion on the bill itself? All right. Then let's go ahead and call the roll. So Delegate Bartlett,
Aye.
Delegate Boucher,
Yes.
Delegate Kaufman,
Yes.
Delegate Pasteur,
Yes.
Delegate Simmons,
Yes.
Delegate Simpson,
Yes.
Delegate Taylor,
I'm a yes.
Delegate Valentine.
Yes.
Okay, and I'm also a yes. Okay. And I believe that's everybody. Just double checking. Nobody else joined. Okay, very good. We're moving on to HB 745. Thank you very much, Ms. Smith, for joining us. Okay, and so we'll need Delegate Shetty. Let's see. The Delegate Shetty.
Colleagues.
Sure. Lisa Jordan, Debbie Feinstein, and Melanie Shapiro. And we will wait a couple of seconds. Let me see. All right. Hello, hello. Okay, I think Melanie is on her way in. And is Ms. Feinstein here as well? Yep. Okay. Okay. Would you do us a kind favor, Delegate Shetty? And would you just summarize like in less than 10 seconds? I'm just teasing. But anyway,
Okay.
so if you don't mind summarizing your bill.
Yes, ma'am, Madam Chair.
That'd be
Thank
great.
you so much. Thank you, colleagues, for hearing this bill. This bill deals, as originally drafted, with protective orders as it pertains to non-intimate partner violence victims. The origination of the bill came from a constituent who has been enduring a tragic 15+ year stalking incident with a very violent stalker who she did not know in advance. She met him through a workplace encounter when she was 16 years old, interning at one of her first internships. This sort of, I'm sorry, so as the law is drafted, the constituent, because she did not have an intimate relationship with her stalker, she was only eligible for a peace order. Peace orders have a filing fee of $86. They have to be renewed every 6 months. The judge does not have the discretion to remove firearms from potentially dangerous stalkers, and there's no pathway towards permanent orders. And so what the bill as drafted did was it adds non-intimate partner violence victims. So all victims of stalking would be eligible for a protective order, which has no filing fee, the discretion to remove firearms, It's eligible for 1 year, and there's a current pathway under the law towards a permanent order. I'm going to set that comment aside for just a moment because that pathway is I'm just going to say that pathway is so restrictive and so flawed that very few to no people have ever been able to access a permanent order because of how narrowly tailored the current law is for permanent protective orders. We heard from advocates that from all that are here and from others that the current law is bifurcated in part because there is a significant difference in lethality for some crimes, in particular for IPV victims. And so having added protections in the protective order and that bifurcation between peace and protective order is important. And so the sponsor amendment, which we worked with all of the advocates on, seeks to provide those same protections of the lengthened order, pathway to permanency, and the removal of firearms for victims of stalking who do not have an intimate relationship, but to do it in the peace order context, as is the current bifurcation in the existing law. So the committee has before you both. You have the current the bill is introduced, which provides those same protections in the protective order statute, and you have the sponsor amendment that we worked with all of the stakeholders on to improve those three areas. But it also addresses some of those challenges and the permanent orders that exist where we try to seek to make it more accessible in general. So it's actually a realistic pathway for scenarios in which it is warranted. So the one thing that the sponsor amendment doesn't do is it doesn't address, well, there are two things. We kind of received feedback after the draft had been more or less finalized, but I want to give the subcommittee the opportunity to consider that the two remaining areas where there's a lack of parity for these victims is in the filing fees. So stalking victims still have to, under the sponsor amendment, pay an $86 filing fee to the courts. I don't know how that was set or when, but peace orders have that. Protective orders, it's waived. And then the last part that we received late feedback on, I think just yesterday, was oh my goodness, I'm forgetting what my train of thought. Forgive me. It will come to me, I'm sure. But I'm happy to answer any questions.
Wow, that was a lot.
I know, I'm sorry.
Thank
It was
you
more
so
than
much.
10 seconds. I apologize.
No. Thank you so much. No, we needed to hear the extent of what the bill actually does and what the
Well,
amendments in
forgive
particular.
me, Madam Chair. I remember the last part that doesn't have parity is under a law that you were successful in passing, Madam Chair. Individuals who are seeking protective orders can file for them from hospitals, from other locations, but people who are seeking a peace order cannot do that. And so I'm just putting that out there for consideration that lack of parity exists still, even with the sponsor amendment. Thank you.
Thank you. And Delegate Boucher, it looks like you have a question.
Thank you, Madam Chair. And thank you very much, Delegate Shetty, for bringing this bill forward. When fee is filed, does the court have the discretion to levy the fee against the stalker to reimburse the petitioner?
I don't know the answer to that question, but I'm wondering if any of my friends here on the call know.
Right. Anybody else?
Debbie, do you know?
Or Ms. Shapiro? Or
Oh, I see.
Yeah, I'm gonna defer to-
Ms.
I'm gonna
Jordan has
defer
her
to
hand
Ms.
raised.
Jordan or Ms.
Okay.
Shapiro. Thank you.
Go ahead, Ms. Jordan.
Thank you, Madam Chair. So as I understand it, your question is can the court order that the respondent reimburse the petitioner? In the protective order statute, it actually says that the court may only order costs from the respondent. So it's not a reimbursement situation. It's just that they can never ask the petitioner to pay those fees, and there is no option to have the court order in a peace order, that the respondent reimburse the petitioner. Additionally, I'll just add, so I don't have to text Delegate Shetty, that the other area of lack of parity between the peace order and the protective order is the catch-all provisions. So there are catch-all provisions in the protective order, but not the peace order. And I will say that from a protection point of view, it's extremely helpful to have the catch-all provision, because it allows you to really tailor the order to protect the safety of the petitioner, that they say stay a certain number of feet away, or that they stay away from a particular area, or that they hand over records, or those sorts of things. So that would be the other area of lack of parity.
Thank you.
And so it sounds like the sponsor's amendment just really creates the parity between both. With that, well, of course, there's these three different things.
It seeks to do that. It seeks to do that, but we
But
failed
there's those
to
three
include
things
a
that
couple of sections.
Right. Okay. All right. And are there any other questions by the committee on this amendment in particular? So does so tell me right now, really truly, what the differences are without this amendment, without your amendment. What right now does a peace order do, and how long does it take, and for what's the length of time that you can have a peace order?
So a peace order needs to be renewed every 6 months. There's no discretion currently under the law for a judge to remove firearms from a dangerous stalker. And there's no pathway to permanency for any peace orders. So there is a current law that would provide a pathway for protective orders to become permanent, but it's so difficult to do that I don't know that it's ever been awarded, or it's very, very rarely, if so. So the sponsor amendment initially sought to address those 3 core components, but then as we were going through it, we realized that there's actually maybe even more that the subcommittee may want to consider.
Okay.
Madam Chair, I'm sorry, I just realized there is actually one more area of parity, and I just, in the nature of providing information, protective orders, there is a way to get a 2-year protective order, and that is not available in the peace order. And I would also just say that, I work primarily or only with survivors of sexual assault, and we do get protective orders. So that does happen in that arena. So protective orders are not simply intimate partner violence. They're also available for non-intimate partner sexual assault cases, non-intimate partner elder abuse cases, and also in child abuse cases. So it is a little bit broader there.
Okay.
Yes, thank you. Yes, Ms. Jordan did very correctly note to me earlier on too that the bill is drafted, so as introduced, would not be like precedent setting, and that it would necessarily include non-IPV victims for the first time ever. There are 3 categories as listed by Ms. Jordan that are non-IPV related, and they are currently eligible for protective orders, which is partially why originally we were looking to just create that parity between the two by just adding this class of victims to that.
And what are those again, Ms. Jordan? What are the
So in addition to intimate partner violence cases, protective orders are also available to sexual assault cases where they're not involving intimate partners. Also to elder abuse cases, which you actually have to kind of weave your way in through. It's a vulnerable adult. So these are not just regular elder abuse cases, I guess I would say, for lack of a more sophisticated term, but these are people who really can't care for themselves. But any case involving the definition of abuse to a vulnerable adult, no matter who does it, could be, a next door neighbor or somebody totally unrelated to family, that's available there. And then for child abuse cases, the statutory definition of either physical child abuse or sexual abuse of a minor. So all of those were included in the protective order, some of them from the outset, and then it was I want to say 2018-ish or so that you added in sexual violence cases not involving intimate partners.
Okay. All right. Does the subcommittee have any other questions? Okay. All right, Delegate Valentine.
Thank you, Madam Chair. I just wanted to confirm that this will be going under the peace order statute, correct? And that this will be the first time any type of provision would be made where a judge could order a firearm surrender under a peace order under any circumstances, correct?
The sponsor amendment would move these same protections for non-intimate partner violence into the peace order. And it would allow discretion for a judge to remove firearms from a dangerous stalker. And I think there are specific circumstances outlined to provide guidance to the judge in doing so.
I move the amendment, Madam Chair.
Okay, we're not
Yes.
going to vote on the amendment yet. Okay. Okay. So, but however, there's still these three outlying kind of considerations. The peace order requires a filing fee. You cannot file it while you're in the hospital or some other area where you could possibly file it, as you can with protective orders. And then also there's this catch-all section that is only in protective orders. Ms. Jordan or Ms. Shapiro, can you talk a little bit about that catch-all piece?
Oh, I love the catch-all. So if I may, the catch-all piece was added in because, these are cases, whether they're stalking cases or intimate partner violence cases or many sexual assault cases, where people really know the petitioner. They know where they live and where they work and their kids. And often we would find that there would be something that the survivor really needed for safety that was not listed on that list. And so we found that we were coming back to the General Assembly year after year. One year we added pets, another year we added, something about visitation. I mean, it was kind of a continual request to try to allow the courts to have enough discretion to truly protect the petitioner in front of them. And so one year the General Assembly had the wisdom to just say, and anything else that's related to safety. So it's not anything else in the world. It's not tort relief. It's not damages, but it is, stay away from my church, stay away from the convenience store I go to down, 3 miles down. It's those sorts of really granular details that create safety. And so that's why that was added to the protective order.
Okay.
If I may add, Madam Chair, that provision definitely was raised by my constituent who has been going through this really horrifying situation for 15 years. She specifically emailed and said that under the peace order, because she didn't have that, basically she became a prisoner in her own home and was unable to go to the grocery store or do other kind of regular activities under the peace order law. So that provision in practice does make quite a bit of a difference.
Got it. Got it. Do you have by chance a document that would kind of line up for us the comparison between already what's in place with a protective order, what's in place with a peace order, and then with the amendment, how that would change? Because I think maybe that might even be helpful as well. Because I do believe we have a little bit more work to do on this.
Sure. I don't, but I can put that together very quickly. I can put a table together that compares key components of each and a checkbox on where the peace order and protective order and sponsor amendment go.
Okay, great. All right. Does the subcommittee have any other questions for our guest? Let's see. Let me just make sure because I seem to. All right. Okay, great. I don't see any other questions.
Madam Chair, if I may.
Yes, go ahead, Ms. Shapiro.
Thank you. I just wanted to add for people as you're thinking about this, the protective order is incredibly, incredibly valuable for victims of domestic violence and other forms of intimate partner violence. However, not all the relationships qualify. So in certain dating relationships, they're not eligible for the protective order because they don't trip the relationship requirements. And so they do access the peace order system as well. So when you're looking at this bill, it's not just victims of stranger stalking that are going to be positively impacted. It's going to be other victims of potentially dating violence. Maybe they've been only dating for 2 months and the abuse started, unfortunately it happens after a first date or a second date. And so they are not eligible for the protective order, but they do pursue the path of the peace order. So as you're looking at this relief that, Delegate Shetty has worked on, and appreciate her efforts in working with all of us to getting it to this place, those are some of the victims that are going to benefit from this.
Okay. Thank you very much. That's really appreciated. Okay. Any other questions or comments? Okay. All right. Listen, thank you very much for being here. And like I said, I do believe we have a little bit more work on this to do. Thank you.
Thank you so much.
You're welcome. All right. So our next and final bill is HB 405. And so we're going to need, of course, Delegate Kaufman is the sponsor. We're going to have Judge Kathleen Dumais, Wendy Lane, Paul Griffin. Let's see, Lori Crowfitz. Oof, hope I didn't mess that up too badly. Melissa Crow, and Mr. Yakov. Okay, and we will wait for them to join us. And then as soon as they join us, Delegate Kaufman, if you will, once they are all in, let's just double check to make sure they're all in. Delegate Kaufman, will you please go ahead and give us a really brief synopsis of the bill?
Yes, I will.
Great.
What the bill does is, and I want to just thank so many people on the call for co-sponsoring it. It specifies certain requirements regarding the qualification and training of custody evaluators, especially related to cases involving allegations of abuse. And the goal of the bill is to protect the safety of children. And that's why I'm gratified that the National Association of Social Workers, American Academy of Pediatrics, and the licensed professional counselors all support the bill. And if I could, I'm just going to say one more thing. I heard a lot about parental alienation at the hearing, but I think that can be dealt with in a separate bill.
Okay, thank you very much. All right. And also you have an amendment. Do you want to speak to that amendment as well?
Yes, I knew that the judiciary was very much opposed, and while I didn't think that I could get them all the way around, I did want to accommodate them as much as I could in good faith. And the amendment, which I'm sorry I thought had been distributed earlier, clearly states that a child custody evaluator does not need to be appointed in every case, just does not need to be appointed in every case, just contentious cases. So I don't have the amendment in front of me, but I think that's the gist of what it says, and that's what my cross-file Senator Carosa put on, and I certainly don't want to overburden the court, so I was happy to follow suit.
Okay. Does the subcommittee have any questions regarding the bill? All right. I think I'm gonna just start off a little bit. So there are a number of requirements in the bill in order to be a evaluator. And are those currently requirements of evaluators? I mean, what's the difference, I guess, is what I'd like to make sure is clear.
Well, what I felt, and I'm having my staff check what as to if there are any new requirements in the bill, but what I felt is that that it was necessary to put it in statute because I did not feel that it was appropriate for the police, for the judiciary to police itself in this regard, because many families came to me and talked to me about how that current system failed them. So there are a number of requirements, but I do not believe I add any.
Okay, so I'm gonna ask Judge Dumais, who's here on behalf of the judiciary, if you could talk a little bit to us about what currently is in place, if any, regarding training and other requirements, and and is anything really codified regarding that?
Sure. Good afternoon, everyone. It's nice to see everybody, even if it's only on Zoom. And I appreciate the invitation to talk a little bit about this. There is an existing rule. It's Rule 9-205.3. But broader than that, the judiciary has been actually working in this area since 2008. We have a work group that is called the Custody Evaluator Standards and Training Work Group that has been in existence since at least 2008. The rule was initially passed in 2016. And the rule actually provides for training, but it's much broader than just training. The rule that has been developed actually goes through sort of when a custody evaluator can be appointed, or when they should be appointed. It gives definitions. There are several different kinds of custody evaluations. Who has the authority to appoint, which is the court on its own motion, or the child's counsel can request, or party can request. It delineates the education and licensing that is required. And I will tell you the education and the licensing is actually the same as what's in the rule. And that actually is a result of some discussions from last year. And so they've picked that up, although there is one place where licensed graduate or master social worker, the rule is actually more specific and requires even more training. It delineates the training and experience. It provides that the court's going to have custody evaluator lists that they can select from. It talks about who can select the evaluator. There's a description of what a custody evaluation is, which again is not included in this bill. It talks about what should be included in the order of appointment, who can remove a custody evaluator, how you use a report in court, what access the court has to it. It indicates when a custody evaluator needs to testify, and also defines fees and how the court will assess fees. So it is a very broad rule and has been in place for quite some time. The rule was passed in 2016. This work group on custody evaluator standards and training work group has been in place for, like I said, since at least 2008. I actually participated in one of the first meetings where we brought in all of the disciplines, including family law lawyers, judges, and all of the people that were doing custody evaluations. There were over 200 people in that room. I will now be, as of January, the chair of this work group, and in my infinite wisdom. But one of the things that I wanted to certainly offer, and I did, we talked about it some last year, is the rule is something that can be changed, and it goes through the rulemaking process. Rules have the same authority as a statute. And it really is just sort of what was the last thing. Really, if the legislature passes something, the court system or the judiciary will acknowledge, will follow it. But we have an entire legislative process within the judicial branch that is done through multidisciplinary work groups, and this is one of them. So we do require training and experience, and not only do we require it, we've also provided it. And I refer everyone to the judiciary's very detailed written testimony that was submitted. We included a copy of the rule so you can see all of the things that I just talked about. And more importantly, it includes a syllabus of a 3-day training that the judiciary put on. About 60 mental health professionals participated in May. We intend to do it again. And you'll see from the syllabus that it covers so many of the things that you all are talking about in this legislation. Nobody in the judiciary is suggesting that custody evaluators shouldn't be trained. But not only are they to be trained in some of these things, they are also have to have professional licenses. So if it's a professional social worker or a psychologist or whatever, or a psychiatrist, although you don't really find psychiatrists necessarily doing custody evaluations. The psychologists, licensed clinical social workers, master social workers. That's who's doing these things. One of the other points I wanted to make clear is that there's a place in the bill that talks about each of these professionals, again, the same professionals that are in the rule, have to have training in, and one of the things is psychological testing. Generally speaking, you do not have the people that are trained in that testing are psychologists. Licensed clinical social workers usually are not, And if they aren't also a psychologist, they're not actually able to administer the tests or to really talk about it. So that I think that would, that's a problem. But, we're all interested in getting the training. I am going to have a meeting of my new work group after the session, and would like to be able to work with the proponents to sort of see if we can add the training that is allegedly not covered in the rule, and so that everybody knows where to look for it. But like I said, it's been going on for a long time. The elements of the existing rule and training for the evaluators is very complete. And then there are unintended consequences. I appreciate the amendment that Delegate Kaufman talked about. But since I've not seen the actual language, I'm still not sure that it's going to be specific enough. As the bill is written, it would include needing to have a custody evaluator, in my humble opinion, in domestic violence cases. Not all custody cases have to have a custody evaluation. But this bill makes it so broad. Number one, based on the training that's required, some custody evaluators who are currently doing it won't qualify. And yet at the same time, the bill is asking us to do even more custody evaluations, which means that we may not have enough custody evaluators to do it. But I specifically wanted to be able to say that I am certainly willing to work with anyone that wants to add something to this rule. That's what this work group that I'm going to chair is about. It will include custody evaluators as well as family law attorneys and other mental health professionals and judges. And, like I said, we would rather work with you than necessarily be in this battle. But I think I covered the question that Delegate Chairwoman Crutchfield asked.
Thank you very much. Delegate Simpson, you have a question?
Yeah, I co-sponsored this with Delegate Kaufman because I just absolutely love the intention of this, and I did speak with some court evaluators before. I was one actually for several years when after my daughter was born. However, I am concerned about some of the things that the advocates have said, and some of the other things. I do wonder if it just needs to be fleshed out a little bit, or maybe, I have definitely experienced and heard from people the concerns that have happened. I've had several just this year, things in Frederick, domestic violence individuals that have gone through the custody evaluators and had some issues because domestic violence survivors don't make the best witnesses. It takes a while. Recovery takes a long time. And sometimes it can be hard to communicate effectively, particularly in the court environment. So in theory, I absolutely love this bill, but I am concerned that when the advocates aren't for it, I do worry about, are we pushing it too quickly? But
look, family law is a and if you were a custody evaluator, you already know this. It's a really complicated area of law, and each and every case is different. And sitting as a member of the legislature for 19 years, I heard lots of family law legislation, and many times it was really hard when you had individuals who did feel like the court did not treat them fairly, or that the decision in the court was wrong or bad. Your heart bleeds for them. But it's hard to necessarily do sort of a global big, that means that's what happens in every case. And I have to admit, courts don't always get it right. There's no question of that. But at the same time, at least the judges that I know and have known for my 35 years of practice or 33 years of practice, they try. When you do the best you can, you're making these very difficult decisions, listening to people over a 3 or 4 day period of time. So I can't say every decision is made perfectly, but I do think that, number one, these custody evaluators, come to this trained. Custody evaluators here in my court are trained constantly and have good experience, and they put their heart into these evaluations. So it's, it's hard to create policy that best addresses all circumstances. because we are going to have those cases where maybe it didn't work. But again, I think the rule, which is much more comprehensive and covers all of the pieces of appointing, handling it, how you handle the testimony, who can be the custody evaluator. If we need to work on adding some additional areas for training, more than happy to work with you on that.
Thank you very much, Judge Dumais. I see Wendy Lane, did you want to comment on the question by Delegate Simpson?
So I actually had a question for Judge Dumais.
Okay, so you're not allowed to ask the questions. It's just the delegates in the room.
Okay,
Because this
thank
is our
you
committee.
for
But you're
clarifying the
here,
rules.
but you're here to answer any questions,
Okay.
okay? So that's why I mentioned earlier, if you had a comment regarding what Delegate Simpson's question was, okay? All right, Mr. Achabam, do you have a comment regarding Delegate Simpson's question or my earlier question?
Okay, so I also wasn't familiar with the procedure. I really want to just make a comment on what Delegate Kaufman said, that he felt that parental alienation would be best dealt with in a different bill. And that might be a proper way of doing it. Just wanted to express our concern that if that is the route that they're going to do, that the language of this bill isn't set up in a way that precludes parental alienation and discredits it. And as I mentioned in my testimony at the hearing and in the proposed amendments that we set in, that there's a number of different provisions in the bill that are specifically pointed at excluding parental alienation and trying to make it sound non-scientific.
Okay. Yeah, so it sounds like what I'm hearing is that, yes, we need to work on the bill and work on the bill together on suggested changes or thoughts about it. Delegate Simpson, you have a question or a comment?
Yeah, for Delegate Kaufman, did he run the amendment by, I mean, where are the advocates right now? I guess is my question on this bill. Because as you know, I don't want to go against, what the domestic violence. I don't want to make things worse. I want to make things better.
Well, what I would respectfully say is that there are many advocates that are in favor of the legislation. For example, like I said, the American Academy of Pediatrics, the social workers, the licensed professional counselors. And so I would also say that that respectfully, Judge Dumais made my case for me because she said the courts don't always get it right, which is why I think this bill is necessary. And then she was mentioning that the rule can be amended. Well, so can laws, because we had passed the cannabis law last year and we're amending it this year. So I think that there is a lot of support for it, just not within the legal establishment.
Okay, and so Delegate Kaufman, with that in mind, one of the things I think Delegate Simpson was really getting at is that you have an amendment that now narrows the bill a bit, and the bill looked like it's pretty broad right now. And so have you gone back to those very advocates and asked them if they have any concerns with narrowing it down, or if there's any suggestions on working towards a product that includes, all parties? I mean, right now, based on what Judge Dumais was mentioning and a few, and also just reading it, it appears as though our current court evaluators may not be even at this standard right now. So that would concern me, and that we may actually end up losing a lot of people as a result of, putting this in place right now. So that's kind of, what I'd like to maybe get your thoughts on. Okay.
Well, like I said, I drafted the amendments to to try to address the Judiciary Committee's concern. I'm in the Judiciary's concern. I will send it to Delegate Dumais as soon as this is over. But and I'm happy to meet with more parties and different things like that, because that's the kind of person I am. And I did meet with Judge Dumais prior to introducing it, and it was Delegate Atterbury who did it last year. And so, but I don't think that the judiciary and I will ever see eye to eye on this, but I'm happy to meet with people. And I just want to also say very briefly that this did not come out, this idea did not come from me. This law came from a 2019 work group in which the judiciary was invited, according to Senator Carrozza, but declined to participate. So I'm happy to talk to people. You know, I think we all care about kids, but in the proponents that testified, they really feel that with their own horror stories, they really feel that, however unintentionally, the judiciary failed their families. So I'm happy to talk and work it through. But I think there'll be some, I don't think I can reach an accord with the judiciary, though.
So on the line, is there a psychologist or psychiatrist or anyone that is currently involved with the process? I'm not sure, Paul Griffin, if you're involved at all.
Yeah, Paul is involved, yes.
Okay. And do you have and Paul, could you maybe comment a little bit more about that and the fact that, you know, what this amendment does, and also how this really affects our current child custody evaluators, if you could.
Paul, you're on mute.
Okay, I'm sorry about that. Thank you, Delegate Crutchfield. What we're seeing are custody evaluators who have little to no training in domestic violence or understanding a lot of the dynamics of child abuse. I think you saw the infamous picture that I brought. That is some pretty horrific domestic violence that's occurring right now in one of our cases. And the custody evaluator there deemed it to be irrelevant and would not consider it in her custody evaluation, which we found quite shocking. Now, luckily, she had lawyers who made it relevant in a trial, but if she had been unrepresented, you know, she gets us for free, we do it pro bono, but had she been unrepresented, she probably would have been pressured into accepting a custody arrangement that's not protecting her or the child. We're seeing this great need for this training. I understand that, and I have all the respect in the world for Judge Dumais, but the rule that they have is not really a rule. It's more of a suggestion. I mean, I don't be flippant, but it says right here under training and experience, subsection 2, that unless waived by the court, a custody evaluator shall complete or commit to completing the following training. So they're waiving it. The judges are not requiring it. And then even if they're not waiving it per se, the person just has to say, yes, I will commit to take this training sometime in the future, but I can deal with this custody evaluation right now. We aren't seeing the training trickle down to the custody evaluators. As far as the amendments go, we agree we don't want custody evaluators on every case. That was an error in the drafting. It should not be that way. It'll be at the discretion of the judge when he or she thinks there ought to be a custody evaluator. And if they appoint one, then they need to have this type of training. We also have another amendment that removed the troublesome language about the testing, which Delegate, or excuse me, no longer Delegate, Judge Dumais is correct. It would have required psychologists, and again, that should not have been in there, and we've approached that an amendment. But the big issue for us, and you know, I'm an advocate in domestic violence and child abuse cases, is we do these cases every day at Child Justice. A lot of the folks who had troubles with them, quite frankly, refer their cases to us for custody cases. You know, this is our bread and butter, and these are the problems we're seeing on a daily basis. I would love to work with the judiciary on this, but I can tell you, I mean, the way the rule is written now, it's not working, and the training is certainly not trickling down to the custody valuers on the line, because they're telling us in depositions or in court, I have no expertise in domestic violence. I have no expertise in child abuse, in a domestic violence or child abuse case. And this is not a one-off. This is something we're seeing quite often. The day before I testified last time, I got another custody evaluation with another domestic violence where the custody evaluator would not consider it. So we're seeing in the field, as an advocate who deals with these on a daily basis, we're seeing in the field a horrific gap in the knowledge base that the custody evaluators need to have. And finally, to address the issue of we'll be eliminating custody evaluators, which is certainly not our intent. Absolutely not. But to be honest with you, the court would be better off with no custody evaluation than an ill-conceived or bad custody evaluation, because it's leading the court to the incorrect conclusions in our view. And it's very difficult, if not impossible, for pro se litigant to litigate this stuff and overcome the assumption that the court is going to have the custody evaluator is going to know what he or she was doing. So our issues are still the same.
Mr. Griffin, let me ask you really quickly,
Certainly.
what
Yes, ma'am.
counties do you usually participate in?
All over the state.
Okay.
All over the state. Now, admittedly, I've not done one on the Eastern Shore yet, but we just haven't gotten one that's a bit difficult to commute, but I'm all over the state. I do a lot in Montgomery County, Baltimore, Baltimore City, Washington County, Frederick, et cetera, Prince George's. Yes, ma'am.
All right. Thank you very much.
Thank you.
Delegate Bartlett, you have a question? Vice Chair Bartlett.
Thank you, Madam Chair. I have a question for Mr. Griffin. It seems to me when I look at the rule that despite the waiver language in the beginning of that training section that you were in, training and experience at number 2, it also states towards the end of that paragraph or that leading paragraph, it states that in addition to complying with the continuing requirements, a custody evaluator shall have training and experience in domestic violence, child abuse. So if you're finding folks who are saying, or custody evaluators who are saying, I don't have any experience in child abuse, to me, or domestic violence, isn't that like the entire crux of the work that custody evaluators are working on? Isn't that like one of the main things that they're doing?
In our cases, they are, delegate. They certainly are. Most cases, I don't know, but certainly in our case, a big chunk of them, I would imagine, are. And I'm not saying they have no experience, but they have no expertise, is what the testimony was from one we had recently. And certainly did not have any individualized training. And I can tell you from talking with professionals in this, the PhDs, the psychologists, and the folks with the masters in social work or what have you, is their individualized training, their specialty does not require in-depth training in domestic violence or child abuse. They may have had lectures on it, but they don't have this great depth of knowledge coming into it, which is why if they're going to be a custody evaluator, they need to have this more in-depth training.
And so just give me an idea of how many hours of training, or is it a degree or something quantifiable that we can point our fingers to when it comes to training?
When it comes to training for this, I don't know.
I can answer that, Madam Vice Chair. My bill requires 20 hours of training, and then I think 15 hours every few years after that.
I'm sorry, I misunderstood the question. I apologize. That's correct.
Thank you.
Thank you.
All right, and I know some of the committee members are going to need to leave. Ms. Crouchek, hopefully I'm pronouncing that correctly. Did you want to comment on the question that Vice Chair Bartlett had? And if so, if you could keep it to like 30 seconds or less, please. Ms. Crouchek, Melissa Crouchek. Okay, she had her hand raised. All right, any other questions by the committee? Okay, all right, let me see. Let me just confirm. I don't see any other questions by the committee. And so what we will do is we will table this as well for now. It looks like we have a lot of questions remaining regarding this, and we should hopefully be able to come back again to it. So with that said, we're going to go ahead and adjourn. And do I have a motion to adjourn the meeting?
So moved.
Second.
Great. Thank you very much. And with that, we are adjourning our meeting. And thank you again.
Madam Chair, I'm so sorry. I wanted to ask one big favor.
Okay, go ahead. Go ahead.
I could hear you all on the bill vote, but I couldn't get in fast enough. On the first bill, I think it was
Gotcha.
406. So
Yes,
yes, so I'm
we
a
actually,
favorable.
yes. Okay, that was, yeah, that was
It
406.
was, yeah, I'm a favorable on the amendment as well as the bill.
Okay, and let me go back through because I think there were a couple of other folks that were not here for that.
Okay, so I just want to make sure that was the communication, right? The marital communication.
Yes,
Okay,
yes, that
thank you.
absolutely was. That is true. Okay, Vice Chair Bartlett, we got you down for a yes on that. And also I see Delegate Tomlinson. Do I see you there as well?
My hand's not up though.
I know. So what I was gonna do is go back because we went through and actually voted on HB 406 and also HB 648. And I didn't know if you wanted to vote on those, and we voted favorably on the amendments as well as the bills for both of those. And I don't know if you want to vote or if you just want to abstain since you arrived late.
Were they unanimous?
Yes, they were.
Yes, you can put me down for them.
Okay.
Thank you. I thought the meeting started at 3:30. I apologize.
It's okay. It's okay. All right. Was there anybody else that missed votes on HB 406 or HB 648? Okay, great. All right. With that said, we are done. Thank you very much.
Thank you.
Thank you.
See you this evening.